Top 5 common mistakes in contracts. The first mistake is not naming the parties correctly. You would think that this is common sense, but yet people sometimes do get this wrong. Sometimes small business owners will put their individual names rather than their business name on the contract, or they may list the other party in the contract under their personal name rather than their business entity name. The problem with that is that the name must match the party entering into the contract because that is the party that will be legally bound to the contract. This also affects who will ultimately be liable under the contract terms. If your company is the party, you do not want to put your individual name because then you, not your company, will be personally liable under the terms of the contract. So always make sure that the parties of the contract are accurately stated. The second mistake business owners do is not limiting their liability under the contract. To limit your liability, there should be a section in the contract called limitation of liability. You can add a paragraph in the contract that can limit your monetary liability as well as putting a specified amount as to that amount of damages that you can be sued for if there is a breach of contract. So you definitely want to limit your liability under the contract. The third mistake is getting the indemnification section in your contract wrong and not limiting that as well. When you agree to indemnify the other party, you are essentially agreeing to pick up the liability for the other side if a third party sues the party you are entering into a contract with. You do not want to be personally liable or responsible for the other party's mistakes against a third party. The fourth mistake is not adding enough language in your contract. Oftentimes, I have clients ask me to draft a contract that doesn't have a lot of pages filled with legalese because the contract may scare the other party from signing it. Not putting the legalese in the contract can end up with scarier consequences. A lot of that legalese is Florida law, and that's required to be in the contract. Some of these clauses were actually born out of litigation. So you want them there to protect yourself. Do not shortchange yourself by keeping your contract too simple and short. The fifth mistake is not having your contract reviewed by an attorney before you sign it. Entering into a contract is not a do-it-yourself project. You should always consult an attorney before you sign a contract. If you sign something you do not fully understand what you are agreeing to, you can end up in contractual hot water. If you end up in litigation, you cannot tell the judge, I didn't understand the contract, or if I knew the contract meant X, Y, and Z, I would have never signed it. The judge will more likely than not say, too bad, so sad. Judges like to look only within the four corners of the document and can only interpret what's black and white in that document. So you better understand what you are agreeing to. So do yourself a favor and consult with an attorney before you commit yourself with your signature. It will actually serve you well and save you a lot of money and headaches in the long run. This is Dina with your legal concept of the day, putting the E's in the legalese. Hope this helps.